Today, I got the opportunity to speak to a class of high school seniors in Washington, D.C. about the ever exciting topic of qualified immunity. And they had some great questions about the Fourth Amendment, about civil rights law. Really gives me hope for the future that there are some great students coming along who are interested in learning about the Constitution. And that got me thinking, what do we need to teach our kids, to teach our students about things like qualified immunity? Most judges don't really understand the concept of qualified immunity. Most lawyers don't understand it. And certainly most just general people out there, and for that matter, police officers as well, don't really understand qualified immunity. It's a very, very difficult topic. So, what are Section 1983 cases generally? If a government officer violates a federally protected civil right, the citizen has the legal right to sue to file a civil lawsuit against that police officer or that officer. It doesn't have to be a police officer. That was by a statute of Congress passed in 1871. It allows for this lawsuit of damages so long as a federally protected right is violated by the officer. You get, at very least, whatever damages you have, plus your reasonable attorney fees and expenses. So that's what Section 1983 cases are. Qualified immunity is the defense that the Supreme Court created out of thin air for police officers generally to these lawsuits. The qualified immunity doctrine is extremely confusing. It's been described as a mare's nest of complexity and confusion. 155 lower federal courts are hopelessly conflicted both within and among themselves, as scholars have noted. One circuit court judge reported that wading through the doctrine of qualified immunity is one of the most morally and conceptually challenging tasks federal appellate court judges routinely face. So, it's a difficult topic. But what do we need to know? It's a creature of judicial activism, not Congress. It's the very definition of judicial activism and legislation from the bench. It wasn't created until the Supreme Court case of Pearson v. Ray in 1967. It was modified mostly to its current form in Harlow v. Fitzgerald 1982, and then modified again somewhat in Pearson v. Callaway in 2009. So that's three different, primarily U.S. Supreme Court decisions that have created this doctrine of qualified immunity. It protects officials not only from money damages in one of these lawsuits, but also from even being subjected to the burdens of participating in one of these lawsuits, so discovery, depositions, and things like that. What is very important to understand about qualified immunity? It's that the officer's subjective motivation is irrelevant. The standard is judged objectively. That means that even if the government official knew that he was violating federal law and intended to violate that federal law, that's not taken into consideration. Rather, the court uses an objective analysis with the theoretically objective person, objective police officer, what he would have known about existing case law as of the date of the act that he committed. The Supreme Court's described qualified immunity as a fair warning standard, and that is, if federal law was clearly established, an official is theoretically on notice that violating that federal law may lead to personal monetary liability, theoretically. Qualified immunity means that public officials are not liable for bad guesses in gray areas, but they are liable for transgressing bright lines. So that is from the case law. That's what the courts have held. Another important thing to understand is it only can be asserted by individuals, individual officers. It does not apply to their employers. It doesn't apply to political subdivisions, cities, or counties. They can't assert qualified immunity in these civil lawsuits, assuming there's a cause of action against them, which is a whole nother video. And remember, you can't sue the state of West Virginia, for instance, for federal civil rights violations. Why? Because the 11th Amendment of the Constitution says that you can't. That's 11th Amendment immunity. Now, why did the Supreme Court create qualified immunity? This is the important thing that we need to teach. Why did they create it? There were two stated policy goals. One, to protect law enforcement officers from financial liability themselves. And number two, to avoid subjecting them to the cost, to the burdens of trial and the discovery process. qualified immunity cannot be justified as a means of protecting police officers from personal financial liability. There was a Yale study of 1,183 civil Section 1983 lawsuits where that showed that police officer defendants paid little to none of any settlement or verdict amounts. Out of the 44 largest law enforcement agencies that were included in the study, which included 70 agencies overall, the individual officers paid just 0.02% of the dollars awarded to the plaintiffs in those suits. In the 37 smaller and mid-sized law enforcement agencies, no individual police officer whatsoever contributed any amount to any award to a plaintiff during the period of the study. All of the officers were indemnified by their employers, even where they were fired or disciplined, or even where they were criminally prosecuted for their conduct. And that's been my experience as well, generally. Secondly, qualified immunity cannot be justified as a means of protecting police officers and government officials from the non-financial burdens of discovery and trial. Why? Studies show, the same Yale study shows that qualified immunity as a defense is rarely asserted early enough in the process to avoid them being drugged through the discovery process, such as depositions. Overall, just 3.9% of cases in the Yale study resulted in dismissal of the case on qualified immunity grounds, where it was even available as a defense. Just 0.6% of cases in the study were dismissed at the pre-discovery stage on qualified immunity grounds. And remember, the second stated policy goal that the Supreme Court used when creating qualified immunity was that we need to allow police officers to avoid even being drugged through the process. But look, only 0.6% of cases were dismissed at the pre-discovery stage on qualified immunity grounds. The overwhelming majority of all cases were not dismissed on qualified immunity grounds. Not even close. Therefore, the existence of qualified immunity is not even serving that alleged policy goal of shielding government officials and primary police officers from the burden of participating as a defendant in these lawsuits. Unless, of course, you consider 3.2% to be a substantial shield from litigation. And to the contrary, as the Yale study argued, it really has increased the negative public perception of a lack of equal justice in the justice system as a whole. I've posted before that there's 3 basically steps to stripping a police officer of qualified immunity. Number 1, the officer's conduct has to have violated a federal statute or constitutional right, not state, federal. And number 2, that the right was clearly established at the time of the conduct, such that number 3, an objectively reasonable police officer would have understood that the conduct violated that right. So which comes first? Until recently, the federal appellate courts required a court to first determine whether or not a constitutional right had been violated, and then to determine whether or not qualified immunity applies. But now, as of around 2009, now courts are free to go ahead and agree that to rule that qualified immunity applies without even really going through the analysis of whether a constitutional right has been violated. What is the real world application of qualified immunity that people need to know? One is that there's generally a grace period between a change in the case law, a change in the law, and the moment violating that law becomes clearly established for qualified immunity purposes. Secondly, qualified immunity is generally a poor defense to excessive force claims. So if a police officer is beating somebody unnecessarily, that's not going to be generally a qualified immunity case. It's going to be more the technical cases involving like search and seizure, things of that nature. So number 3, qualified immunity is a very effective defense in dealing with those technical Fourth Amendment search and seizure cases, especially if it's sort of a gray area. It's basically about mistakes. So number 4, an officer's mistaken understanding of the law or their reasonable misapprehension of whether their conduct was constitutional or not, that does provide a defense under qualified immunity. So it it applies to just really gray area sort of cases, and is not supposed to apply to those sort of situations where every police officer should know that that sort of conduct violates a federal constitutional right. So, for instance, a police beating cases or searching a house without a warrant. Really, really clear-cut cases is where qualified immunity can be beaten. So, ironically, qualified immunity ends up not being much of a bar to a plaintiff in a lawsuit seeking to hold a police officer responsible for those cases that we see on the news, like George Floyd, for instance. There's no court in the land who would give that police officer qualified immunity. Why? Because it's obvious to any police officer that you're not allowed to engage in excessive force. And there are a lot of cases to point to in the case law of similar sorts of conduct where the qualified immunity has been found to have been unconstitutional and been denied. Where qualified immunity has been denied and the conduct has been declared unconstitutional. So I really would agree with the Yale Law Review study that we don't need qualified immunity. It is a creature of judicial activism. Congress did not pass it. There were two stated policy goals, neither of which are being served. And the way it turns out is it's not really applying as a defense to the really bad cases that we're upset about. It's applying in situations that are really unfair in practice. You can contrast two recent examples of qualified immunity, both of which I've posted about on my website at thecivilrightslawyer.com. Look at the post I did a few posts back on the Sixth Circuit denying qualified immunity for the arrest of the man wearing the F the Police t-shirt. And that's from when in 2016, police officers in Ohio pulled this guy out of a crowd because he was wearing an F the Police t-shirt. They taunted him about the shirt, ultimately arrested him for so-called disorderly conduct. Eventually, the Sixth Circuit Court of Appeals issued an opinion denying qualified immunity to those officers in the civil rights lawsuit. Remember, how do you strip a police officer of qualified immunity? 1, the conduct has to have violated a federal statute or constitutional right. 2, the right was clearly established at the time of the conduct. And 3, an objectively reasonable officer would have understood that their conduct violated that right. So using that three-step analysis in the F the Police t-shirt case, what rights were violated? Well, the Fourth Amendment was violated. There was a false arrest, a warrantless arrest where there's no probable cause justifying that warrantless arrest. That's a federal right that's violated. In that case, also, you had the First Amendment and the 14th Amendment due to the First Amendment retaliation that took place. The F the Police t-shirt was constitutionally protected speech. It's been clearly established, as the court set out in the opinion, that a state cannot criminalize the display of a 4-letter expletive without more. The facts were that they removed him from the crowd under an armed guard, and that obviously would be sufficient to chill somebody's freedom of speech. Therefore, even looking at the officer's motivations and removing the plaintiff under armed guard, and it indicated it was because of the shirt. So it was constitutional to wear the shirt. They removed him under armed guard for wearing the shirt. That is a sufficient action to constitute retaliating on somebody for their First Amendment protected activities. So therefore, qualified immunity was denied for police officers unconstitutionally arresting the guy with the F the Police t-shirt. That's a recent case out of the Sixth Circuit. Now I also posted about one from the 11th Circuit. 11th Circuit, that's where the police officer granted qualified immunity after shooting the innocent homeowner at the wrong address. And I'll put links to these decisions and my posts on these decisions in the description to review them. Also, 2016 case out of Henry County, Georgia. That's where the police sergeant arrived at the wrong house. From the shadows, basically, he ends up shooting and killing the innocent homeowner who was standing in his driveway trying to figure out what the dogs were barking at outside. And he never said police or gave any indication to the homeowner that there was a police officer out there with a gun that was about to shoot him. Just shot first, basically. And the courts ended up denying granting qualified immunity for the officer and dismissing the lawsuit. So why? Let's look at the same 3 steps. Number 1, the officer's conduct violated a federal statute or constitutional right. Number 2, the right was clearly established at the time of the conduct. And number 3, an objectively reasonable officer would have understood that the conduct violated that right. So number 1, what rights were violated? Well, Fourth Amendment is the issue here. This is an excessive force analysis, a deadly force analysis. Generally, an officer may use deadly force if he has probable cause to believe that the suspect poses a serious threat of physical harm, either to the officer or to others, and that he's committed a crime, or that he's committed a crime involving the infliction or threatened infliction of serious physical harm. And 2, reasonably believes that the use of deadly force was necessary to prevent escape. And 3, is given some warning about the possible use of deadly force if feasible. So that is from Tennessee versus Garner. That is the law of the land from the Supreme Court on police shootings. So what did that say? He's given some warning about the possible use of deadly force if feasible. In the end, that's where the court went with this, is that the plaintiff claimed that police always, under every circumstances, have to give a warning before using deadly force. And the court, unfortunately, I think it's the wrong decision, but granted qualified immunity, finding that, that's not exactly the clearly established case law, because the Supreme Court said, if feasible. The court explained that under some circumstances, under many circumstances, the officer has an obligation to warn before shooting, but not every circumstance. And the way the facts played out in that case, it was such that qualified immunity went in the other direction. So, like I said, qualified immunity really, who wins there? When it really applies, it applies under unfair circumstances. There is no need, as per the Yale study, for police officers to be shielded from this financial liability, because they have no financial liability in practice. There's insurance coverage provided by the employers. They indemnify any settlements or verdicts. Even where prosecuted, police officers haven't been paying anything. The second policy goal is not met as well, because they're still participating in defense of the cases. And the insurance policies, the taxpayers are still paying anyways, even with the qualified immunity defense, to defend the cases, because it, for various reasons, it is not asserted as a defense or cannot be asserted as a defense effectively. So it's not meeting any of the stated policy goals. It's judicial activism that is really un-American, and it's also really putting a bad light on the criminal justice system, on police and law enforcement in general. But that's about as quick as I can explain qualified immunity in the context of, what every student coming out of high school really ought to know, or even college, or even law school for that matter. But it's very, very difficult. That's just the really brief overview. But hey, that's about the best as I can explain it. But it was really cool being able to talk to a group of students today in Washington, D.C. who were interested in this topic. And I didn't get to even go into all that. So perhaps they'll see this video and get to see my explanation of qualified immunity in general that we didn't even have time to go over. So thanks for watching.